This conference will now be recorded.
I'd like to welcome everybody who's joining me today, Wednesday, May 12, 2021, for our webinar, Where There's a Will, There Are Relatives, How to Protect Your Estate Plan. Now, I'd love to take credit for the title, but I can't because this is actually the title of a play that was written many years ago. And the opening scene of the play is the home of the person who has recently passed away, and the immediate relatives have gathered not so much to pay respect to the individual that died, but they're busy talking and squabbling about what they think each of them is going to inherit. During the play, they come to find out when the last will and testament is formally read that the gentleman who died, who happened to be a very wealthy person, left all of his estate to a charity. It happened to be a church. And so I loved when I read the play and I loved the title, and I thought this is a great way to talk about how to prepare and how to think about the reaction or the last thought you're going to leave people with. So I know some people who are attending today have a concern as to how a will should be written to try to avoid somebody in the family or perhaps a friend contesting the will or contesting the trust after death. So we're going to talk a little bit about will contests. I've heard from some people that they hear a rumor that if you leave somebody at least $1 who you really intend to disinherit, that then everything will be fine and that person does not have any legal basis for contesting your will. So we're going to talk about that as well today. Then I've also heard concerns about, well, what if I have a beneficiary who is ill, or perhaps was born with special needs or a disability? How do I set up their inheritance so I know when I'm no longer here, they're going to be taken care of, because I know that they're not capable of managing the inheritance I'm going to leave them. And if these concerns were not the reason you're joining in today's webinar, but you're worried about leaving behind people that may be jealous, there may be division in the family, and you want to try to avoid that, we're also going to talk about tips to achieve that goal as well. So we're going to start today and talk about what's called a penalty clause. So a penalty clause simply means that if you wanted to write in your will that if somebody contested what you left them or didn't leave them, they would lose their inheritance. Unfortunately, that kind of clause is unenforceable in the state of Florida. And the reason we don't allow it is because the court system encourages people to take action if there's a valid basis to correct a wrongdoing. So we want to promote that the courthouse is open to anyone who has evidence to prove that a will was procured either because of fraud, duress, a mistake, or perhaps undue influence. So let's talk about what each of these grounds truly means. So fraud would mean that the person making the will, we call them the testator if they're a man, or the testatrix if they're a female. These are Old English Latin terms. Let's say that somebody befriended the testator and maybe even convinced that person to marry them, thinking that they were in love with them. That would be an example of fraud. And then if the person who convinced them to marry them then convinced them to leave everything they own to them in the will, that could be a basis for contesting the will and setting it aside if fraud was involved in convincing this gentleman. And sometimes we see this when an older person is a widow or a widower, and perhaps they're very wealthy, and they have become a target, or we could say a victim, of somebody's malintent. So this would be a valid basis to seek to set aside a will. Another ground would be duress. So if you look at the picture on the PowerPoint, there is a person sitting on a couch with a person standing in front of them pointing their finger. So duress would be, let's say, a caregiver taking care of somebody who's frail, and they are misusing their position of authority. And they're saying to that person, if you don't do what I tell you to, I'm going to walk out and you won't have anybody left to take care of you. So that's an example of duress. So if a will or a trust is signed by a person under duress, they're really not doing it of their own free will. They're not doing it voluntarily. And so that's an example of a will or a trust that we would want set aside and the correct outcome achieved by going to court. An example of a mistake that could affect how a will or a trust is written is perhaps a woman coming forward and saying to a man, you slept with me, and as a result, I got pregnant, and here's your child. But the man doesn't have any kind of paternity test done, and he just relies upon the woman's statement, and as a result, includes that child in the will or the trust to receive an inheritance. So that would be an example of a mistake, that the will or the trust is written based upon this misguided belief that this child is the man's own blood when it's actually not. And undue influence is a higher level of the duress example, where somebody is taking their position of trust and they're misusing it. Now, undue influence could be exercised by a family member as well as by a non-family member, such as a paid caregiver, perhaps a home health aide that is provided through an agency, or somebody that is not coming through an agency. Maybe they're through a registry. It could also be a neighbor. Believe it or not, we see a lot of situations that end up in the guardianship court where neighbors exercise undue influence. So an example of undue influence would be an older person who's a widow or a widower, and their spouse has passed. Perhaps they don't have children, and they're becoming frail. Perhaps they need assistance, and so a neighbor offers to assist them. Could be that they're doing yard work, perhaps they take them food shopping, maybe they're preparing meals, and they start to get very close with this older adult. And then they say, well, you don't really have anybody close by to help you, so why don't you name me in your legal documents, and I'll help make your medical or your financial decisions when you need it. And then the next thing that happens is the neighbor arranges for the older adult to have an appointment at a lawyer's office. But instead of the older adult making the appointment, it's the neighbor who does it. And it's the neighbor that provides the transportation for the older adult to get to the appointment. And that neighbor might even sit in on the meeting between the attorney and the older adult. And it might even go so far as the neighbor telling the attorney what to write in the documents, especially in the last will and testament, or perhaps the revocable trust. So each of those steps shows a very strong likelihood that this neighbor or caregiver is exercising undue influence over the older adult, and the decisions that are being made really don't reflect the true desires of the older adult. That maybe their physical body is weak, maybe their cognitive state of mind is weak. And so that's an outcome we definitely want to correct by going through the court process to set aside the will or set aside the trust. So believe it or not, before this webinar, I did a quick search on Google because I was curious if there were any surveys about the percentage of Americans that do not have a will, and it's pretty high. The most recent survey said that 68% of Americans die without having a last will and testament. So in order to appreciate the importance of making a will or a trust when you're healthy and when you're sufficiently mentally aware, it's important to understand the outcome of what happens when you don't make a will. So when you don't have a will, it is called to die intestate. And we have statutes, laws that say what happens, how are the assets distributed to a surviving spouse or to descendants. So there are a couple of possible outcomes I want to walk you through if the person who died has a surviving spouse. So if they're married and there are no children, either from that current marriage or any prior marriage, the surviving spouse is going to inherit 100%. However, if there are children in addition to the surviving spouse, and they're children that belong to both the decedent and the spouse, either born naturally or adopted, then the surviving spouse still receives 100%. However, if the children that survive the decedent belong only to the decedent, let's say through a former marriage or a former relationship, but they are not the children of the surviving spouse, then the surviving spouse only inherits 50%, and the remaining 50% is divided among the living children. Now, if somebody passes away without a will and there is no spouse, then we have a different statute. And what we're basically looking at is who is the next of kin. So we're looking at the bloodline. So we're going to see if there are any living parents or grandparents. And if there are none, then we look to see if there are living siblings, brothers and sisters. And if there are none, there are other categories in the list that we have to go through. So we're going to look at aunts and uncles, we're going to look at nieces, nephews, cousins, until we can find somebody that is alive in one of those categories. I also want to mention, because sometimes I'm still asked this question, a handwritten will is not considered valid in the state of Florida. And this is the case in most states in the country. The will must be typed, and to be valid, it has to be properly signed in the right locations, witnessed, and notarized. So in Florida, the person, the testator or the testatrix, has to sign the will at the very end. It needs to be dated. We then need to have 2 adult witnesses over the age of 18 sign their name, and everybody has to be in each other's presence. So it can't be that I'm in one location and the witnesses are in another. Then we have a notary who notarizes the document. And then the last, but probably one of the most important pages, is called the Self-Proof Affidavit. So this affidavit says that the testator, the witnesses, and the notary were all in each other's presence. They saw each other sign. So that page is signed by the testator, the 2 witnesses, the notary, and then it requires the notary's stamp. If any of those steps are missed, a will is not going to be considered valid and it's not going to be accepted into probate. So what do you need to know if there is a family member that you want to disinherit and you don't want to have any problem after you've passed with any kind of contest? So the first answer is, in Florida, we have a law that protects a surviving spouse. So you cannot say in your will that you're disinheriting your spouse unless before you got married, the two of you signed a prenuptial agreement, or after you were married, you signed a postnuptial agreement that specifically states the two of you are waiving your legal rights to inherit from the other spouse. So unless we have that in writing, your surviving spouse by law is entitled to receive 30% of all your assets. Now, I'm emphasizing the word all because all means not just the assets that might have to go through the court system called probate. It means all the assets that avoid probate, such as assets that might have your spouse as a joint owner or your spouse designated as a beneficiary. It also includes assets that name another person as a joint owner or another person as a beneficiary. So what happens in a situation where a spouse is accidentally disinherited, we have to identify all the probate and non-probate assets. We then have to value what they were worth on the date of death. And after that, we calculate what is 30% of the total assets. Once we calculate the 30%, then we look to see what assets did the spouse receive, either because they were the joint owner or they were designated as a beneficiary. And we look at those values, deduct them to see what remaining sum, if any, is that surviving spouse entitled to. At that point, the law directs us to satisfy that remaining sum first from the probate assets, and if probate assets are not enough, then we have to collect the money from the non-probate assets, the assets that somebody else directly inherited. So to avoid all that work having to be done and that kind of outcome, leave at least the 30% or arrange with your spouse for a prenuptial or a postnuptial agreement. Now, we also have a law in Florida that says a parent cannot disinherit their minor child who was born after the will was signed, unless you state in your last will and testament that you are doing that intentionally, or unless you had other children who were born when the will was signed and you've left most of your estate to the other parent of the child born after your will was signed. So Florida does protect the surviving spouse, and it protects a minor child who was born after the will was signed, but the testator never updated the will before they died. So what else do you need to know if you are going to disinherit a family member? Well, one tip that I can give you that I think helps to avoid a successful will contest would be to state why you are disinheriting that adult relative. For example, if while you were alive, you made a gift to that particular, let's say, son or daughter, and you feel that that should satisfy any inheritance, then you want to tell the attorney that so they can write that language in to the paragraph explaining why you're disinheriting that adult son or that adult daughter. If, let's say, the reason for disinheriting is because that person is very wealthy and they really don't need the money like the other beneficiaries do, then again, you want to have it stated that you're not leaving an inheritance to that beneficiary because they're affluent in their own right. Or if perhaps you've lost touch with a relative, or the relationship ended on a very bad note, there was an argument or a disagreement, then the paragraph in your will should state that the reason you're disinheriting that person is because there's a lack of a continuing relationship. By stating the reason for disinheriting, you're showing a future judge who might be presented with your will that you were very aware at that moment. You made a very careful and conscientious decision. And you don't need to say in the will that you're leaving that person $1. Doesn't matter whether you said $1, $5, $10, it's not going to prevent them from going to court and contesting your will. But showing that you were aware, you thought about this, and you made a very deliberate decision is what is more likely going to cause a judge to rule in favor of upholding the decisions that you made in your last will and testament. So how do we protect a vulnerable beneficiary? Let's say we have a beneficiary who has Down syndrome or autism or cerebral palsy. And for physical reasons or perhaps mental health or cognitive reasons, they would not be able to actually manage their inheritance when they receive it. So in that instance, it's again important to share with the attorney information about the beneficiary, and a special needs trust should be written in your will or your trust to hold the inheritance for that beneficiary. A special needs trust will allow you to select who you would like to manage the special needs trust. We call that person the trustee. You'll also want to select a successor trustee so that if the first person you name becomes sick, incapacitated, or dies unexpectedly, you have a plan B, and that's going to be your successor trustee. Another benefit to having the special needs trust written to hold the inheritance is that if your beneficiary, because of their special needs, is receiving financially sensitive benefits from a government agency, such as Medicaid, SSI, food stamps, or subsidized housing, the receipt of that inheritance will not cause the beneficiary to lose their entitlement. Yes, we will need to inform the government agency that you died and you left an inheritance in a special needs trust for that person. But once the government knows it's in a special needs trust, they will realize that the beneficiary has no direct access or control, and for that reason, they're not going to count the inheritance as being available. So what that means is your beneficiary will keep their government benefits, and then the special needs trust assets can be used to supplement and enhance their quality of life and quality of care. And hopefully that means that the inheritance will be stretched out and last longer to help this individual. Well, what do we do if you have a beneficiary who's just irresponsible? Maybe they're not mature, they live beyond their means, they rack up credit card debt. What do we do in that situation? You still want to leave an inheritance, But you know, if you leave it directly to that beneficiary, they're just going to spend right through it in no time at all. So we want to consider writing a different kind of trust, where perhaps you give the trustee the authority to dole out money at different time frames, hoping that the older the person gets, perhaps they will become more mature, more responsible. Or let's say your beneficiary is irresponsible because they have become addicted to alcohol or drugs or gambling. Well, we can write the trust in a way that if the trustee suspects that the beneficiary is abusing alcohol or drugs, that they can stop making distribution. So it's like we can turn the faucet off or we can turn the faucet on. And we can include language that would allow the trustee to require the beneficiary to produce a urine test or a blood test to prove that the alcohol or the drugs are not in their system. And if they are testing positive, then we can have language in the trust that gives the trustee the authority to use the trust assets to pay to get your beneficiary into a rehab center to get help. So there's a lot of creative ways that trusts can be written and tailored to meet the needs of a particular beneficiary. What if you're concerned that your beneficiary might get divorced and you don't want the divorcing spouse to be able to get their hands on the inheritance? Well, in that case, you might want the beneficiary's inheritance to be held in a trust, and that way they have no direct access, no control or availability. So if they do get divorced, none of that inheritance should be available to be divided in the divorce proceeding. So here are some tips I'd like you to consider as you're taking the next step, which I hope is going to be to put some of your ideas on paper and call and make an appointment for an estate planning consultation. My first and probably most important tip is please don't procrastinate. Get this done and sign your will or trust when you're healthy and you're competent. Many people are afraid or they're superstitious that talking about a will, or making a trust is going to cause death to occur. And I can appreciate that facing our mortality can be very scary. But I encourage everybody to do that, especially because we've just lived through a very difficult year, a very difficult time in our history of this entire earth of surviving the COVID-19 virus. So like they say, don't put off tomorrow what you can do today. There's no time like the present. So please don't procrastinate. Now, if you're not in good health, let's say, or perhaps a person is starting to have some memory loss, either because of natural aging, or perhaps there's a diagnosis, or perhaps they had a head injury, it might be a good idea to video the signing, because it will, if God forbid there is a will contest, it will enable the judge to look at the video and see, first of all, who was present in the room. How did the testator or the testatrix act? What was the dialogue like? Does it show that this person was aware, was competent, knew what they were doing, and did it voluntarily? So while I don't like to have to rely on videos, it is a tool that we have available to us. My second tip is it is so important to sign any legal document correctly. Now, usually I get at least one person on a webinar who will ask me the question, well, can I just download a document from LegalZoom or go over to Office Depot or Kinko's and buy a legal document and do it myself? Well, the answer is yes, you certainly can. However, number one, that piece of paper and the clerk who works at the store isn't going to talk back to you, isn't going to ask you questions, isn't going to be able to give you the tailored legal advice you need to make sure it's written correctly and that it's going to produce your desired result. And if you don't sign it correctly, it's missing a witness, it's missing a notary, it's as if you didn't write anything at all. My third tip is don't allow a potential beneficiary to be with you when you sign the document. The preference is they shouldn't be at the lawyer's office and they certainly should not be in the room at the time that you're signing your document. I also highly recommend that you find the attorney yourself rather than allowing a potential beneficiary to find the attorney. If you think back in the beginning of this webinar, we talked about what are considered grounds for contesting a will. And we talked about fraud, duress, mistake, undue influence. Well, there is a case called the Carpenter case where the court in Florida laid out step by step everything that had happened, everything that was done at the fingertips of that person that was exercising the undue influence. So you want to avoid all those steps. Find the attorney yourself. Don't allow anybody other than the lawyer and the witnesses to be in the room. And when you're meeting with the attorney, don't allow that potential beneficiary to be with you. It should be a private conversation between you and your attorney. It's also a good idea to meet with your attorney yearly. Go over your estate plan. Talk about whether there have been any changes to the law or changes you want to make because either relationships have changed, beneficiaries or fiduciaries have died or become incapacitated, or perhaps your financial situation has changed. By meeting with your attorney and having your attorney document the meeting, it's going to show a judge you were attentive, you sought out information, and you were making informed decisions. Now I'm going to stop because I see there is a question in the chat box. And the question is, do other states recognize a Florida written will? For example, if somebody first lived in Florida, had their will written, and then they relocated to Texas, and that's where they die, will the Texas court recognize a Florida will? Well, I can answer the question as to how Florida treats wills that were written in other states, and not just wills, any legal document such as a durable power of attorney or a designation of healthcare surrogate. Our law says we will recognize a legal document written in another state so long as it met that state requirements. So if the other state required you to sign in the presence of one witness or two witnesses and a notary, and that's what was done, we will recognize and honor that document. But if the document from the other state wasn't done correctly to meet the other state requirements, then Florida is not going to honor it. And I would venture to say that most states in the US have a similar law. And the reason for that simply is that for probably the last 30 years, we have become a country where families don't necessarily stay in the same state, the same city anymore. We have families that are spread out throughout the country. You might have parents in Florida, but children in California, children in New York, and the Midwest. So the reality is we can't require every time somebody relocates for them to have to redo their documents. We want to make the documents transferable, transportable. It has to be practical for people. Now, it's still a good idea to, when you get to that new state where you've relocated to meet with a qualified estate planning lawyer or elder law attorney. Have them review your documents, because maybe it's been 10 years since your documents were prepared and you just never went back to the original attorney. It's a good idea to know what has changed in the law, what might affect how your documents were written. So I do suggest a checkup. I'd like to say yearly, but if that seems too frequent, then my suggestion is going to be every 2 to 3 years. Go to see your attorney and have an estate planning checkup. Thank you for that question. So at this time, I'd like to open it up to any other questions anybody has about estate planning, wills, trusts, or any related concerns. Well, if there are no questions, I'd like to thank everybody for joining me today. We are hosting another webinar next week in honor of May being National Elder Law Month. So I hope you'll go to our website, www.fl-elderlaw.com, and register for the next webinar. You'll also, as I mentioned, be able to find all the recorded webinars from the past year. They have the title and the topic. And don't forget that on our website, we have a complimentary gift certificate that provides a 20% discount on the estate planning consult or long-term care planning consultation. So I want to wish everybody good health. Have a great rest of your week, and thank you for joining me today.